Ci apprestiamo ora a iniziare il nuovo modulo sugli strumenti di difesa commerciale con il dottor Valeri Rodriguez. Can you hear us, Enrique?
Okay, thank you. Can everyone hear me?
We can now hear you, yes.
Yes.
Thank you very much. Ok, we can then start, possiamo iniziare il modulo aggiuntivo sugli strumenti di difesa commerciale. Please, Enrique, I'll give you the floor.
Okay, thank you very much. I'm going to try to share my screen because I have a presentation. So now, can you see my screen?
Yes, we can see the screen. Yes.
Okay, so okay, so first of all, I know it's late, but it's good that the ones that remain have interest. So to begin with, good morning to everyone. My name is Enrique Valerdi. I work in the Directorate of Digitrade that handles trade defense, that is Directorate G. First of all, thanks to the Italian colleagues and for the interpreters that I understand will remain more than was scheduled, for the organization and for giving us the chance to speak here briefly about trade defense. Okay, so I will try to be short because it's late. But as introduction, what is trade defense about and why it's important that the small and medium companies know about it? It is basically about the question on this slide. Imagine you have a company, a small company, that produces and sells products in the European Union market. Everything goes well, you are growing, you're creating jobs, you're contracting people, and one day your clients tell you, okay, I'm not buying from you anymore, because producers from outside the union are offering exactly the same product at much cheaper prices. You have a company, you see these prices, they are abnormally low, you cannot compete against that. So the question is, can I do something about this? And that is precisely the role of trade defense, and that's the message I hope to pass, and especially for small companies, that trade defense can have an impact on your business in the union, and that knowledge about it can help your companies, and that there are resources to learn more about trade defense specific to small companies. Now, why do we have trade defense? As we all know, international trade is an engine for economic growth and welfare, and that's why the European Union is committed to open markets and free trade. But then free trade must be fair, and that's not always the case. There are some concrete trading practices that are unfair and can damage European Union producers. And the European Union has to protect its citizens and companies against such practices. And that's the reason to have trade defense instruments. They are a tool to counter such practices and restore a level playing field in the union market. Okay, so to recap three main points about trade defense. The objective, as I said, is to protect European production from certain unfair trade practices when this cause damage to the European Union industry. I mean, three words here are important: is production, it's a tool to defend domestic producers; certain, that it can only address concrete practices, you cannot use it against everything; and harmful, we can only act when those concrete unfair trade practices are causing damage to the European industry. So it's limited in scope. Another important thing is the form. We act against unfair trade practices on trading goods. So these are goods that cross borders, you do customs clearance. So the protection takes the form of normally a duty on imports, which also means that it's product specific, and like all duties, it has a significant impact on all players in the union. And the third thing that I would like to point out is that trade defense is a matter of fact and law. All we do has to be compatible with the WTO agreement, with the WTO legislation, and with a basic regulation in the Union. This is not only on substance, this is also on the procedure. Then, regarding the facts, it is normally demand-driven, which means that an industry needs to come to us and ask us to act on the basis of a complaint. And then it's only done after an investigation that requires concrete data from concrete companies, which means, and I will explain this later, that cooperation from companies, it's crucial. It's what starts the process and what shapes the result. Okay, for a bit of substance and following from the previous slides, I talked about concrete distortions. What can we act against? We have three instruments: anti-dumping, anti-subsidy, and safeguards. The most used is dumping. So each one is for a concrete distortion. Dumping address dumping, which is exporting a product at a value lower than the normal value. Subsidization addresses subsidies, and safeguards address a surge of imports into the European Union. This is just an overview, and I'm not going to get into the substance, but to touch briefly on the conditions to impose, these are four. The imports have to be dumped or subsidized, or there have to be a surge of imports. There has to be injury to union producers. When we talked about injury, we refer to a deterioration of the economic situation of the domestic industry in the union market. There are two remarks here. It is the whole industry, not just 2-3 producers, and it's concretely their performance on the union market. Third, we need a causal link to impose measures. The causal link means that the injury to the union producers has to be because of the dumped or subsidized imports. And the final requisite that we have to impose anti-dumping or anti-subsidy measures, and also a safeguard, is that they cannot be about the whole interest of the union. So in our investigations, we do what we call the union interest test, where we analyze the effects of imposing or not measures on all interested parties in the union. And this includes importers and the user industry. The union interest is a balancing act, and the decision is binary, is duties or no duties. We cannot modify the level we found. But in practice, this means that knowledge about trade defense is also very important for importers of the product against which we open an investigation and for the user industry. Now, to sum up the previous two slides, trade defense are tools that may have a big impact on companies and on which companies have a role to play. They initiate the process, they are subject to investigation, we ask you for data, and they are subject to different deadlines in the investigation. This requires a lot of resources and knowledge on the side of companies, which leads us to small and medium companies, and possibly the most important slide of this presentation. The QR code you see there links to Digitrade's website on trade defense for SMEs. Everything I'm going to say in this presentation is there, and you can find more resources also in Italian. So while I go on, I would like to ask you to please take out your phones, scan the code, and store it somewhere where you can find it later. Now, why small and medium-sized enterprises? As has been said in other parts of this Market Access Day, they're the backbone of Europe's economy. They're 99% of all business in the Union. They employ 83 million people, which is roughly 64% of employment. They're more than half of Europe's GDP, and they play a key role in adding value. Now, normally, as we also said in this Market Access Day, they have less resources than bigger companies. As I explained before, trade defense is very technical, it's subject to strict rules, and requires active involvement from companies. And then it can have a high impact on the activities of companies in the Union. So the purpose of the Commission is to facilitate access to trade defense for small and medium companies. That is the reason for the website and the other resources, to explain what trade defense is, why this may matter for your company, and how you can use it or react. So to put it in plain words, if you believe that your company or an industry is facing unfair competitions, or if we start an investigation that concerns one of your input materials, or simply if you're an importer and we open an investigation against something you import, the information that's there is relevant for you. Okay, now I'm going to get a bit on the substance, but the idea is to give examples of how trade defense works so that you know why it can be important for you to know more. I mean, this is on the procedure first. I already said it's demand driven. So investigations are normally initiated based on a complaint by the union industry. We can also do it on our own initiative, but this is very, very, very uncommon. But this means that you come to us and then we start the investigation. And this means that you have to lodge a complaint. The complaint needs to have sufficient evidence justifying the initiation. You cannot come to us, just one company, and say, I believe country X is dumping. And another thing, but this is all explained in the website, it has to be lodged by the union industry. It's not just two companies. You need a certain size. So organization of the companies at union level is critical. The second point is, as I said, that the remedy is imposed following an investigation. The investigation is fact-based. This means we go out, and also on the European side, we visit companies, we ask for a questionnaire, and we verify this data. We do this within a procedure that has very tough deadlines. So companies need to be ready, and it's good that they know what is expected from them if they want to cooperate on an investigation. And cooperation is crucial because it's what shapes the result. And the third point is that everything is rules-based. As I explained, everything has to be according to WTO and our own basic regulations. That's on substance. But the procedure and timing, the deadlines, are also rules-based. And then there are other parts of our basic regulation that regulate the rights of parties, the confidentiality of data, and the rights of defense. So, for example, it's good for a company to know that once they register as an interested party in an investigation, they have rights, they can submit information, they can access the non-confidential file of the investigation, so they know what's going on in advance, so they can react. That's very good for importers. A point where normally small companies are concerned is the restricted use and confidentiality of data. I mean, confidentiality of data is respected where warranted, and we never publish confidential information, and we don't even share it. This is concrete company data, even inside the commission or outside the directorate. And the same is for rights of defense. Once you register as an interested party in an investigation, you acquire certain rights of defense. Okay, here is another example of why knowing more is useful. In this slide, you see the timeline of an investigation with different stages. And I show also what would be required of union producers when and the different deadlines. Time is short, so I'm not going to explain everything, but for example, how can this information be useful for you? I mean, suppose you are a producer and together with others, you lodge a complaint. You want to start the procedure. Then by visiting the website or asking the SME help desk, you would know that the Commission has 45 days to take a decision on whether to initiate an investigation, and that some 25 days after you officially lodge that complaint as an industry, your company will receive a standing form that asks them to provide certain data with a deadline of normally 10 days. All this is explained on the website. Now, here I want to talk about the impact and why this is important. The next two slides will explain what's at stake for companies. And this is a very easy example of how an investigation gets us to the concrete duty. I mean, company A in a third country sells domestically at the equivalent of 100 euros, but then it exports to the union at 75 euros. The 100 euros would be what we call the normal value, the price on the domestic market, and the export price is 75. So they're dumping exactly 25. That would be the normal value minus the export price. Then to ship to the union, let's suppose this arrives at the union border at 80 euros, including freight, and then that the import price in the union is 80, meaning there are no customs duties or other charges. This would translate in an anti-dumping duty of 31.25%. I mean, this duty theoretically corrects the unfair practice. It corrects dumping. Why? Because as you see in this slide, the CIF price at the union border plus the AD duty would raise the price in the union to 105, correcting exactly the 25 of dumping that was found. So what happens in practice is that imports entering at a dump price would now do it at a fair higher price. The impact is clear for union producers of the same product. They compete on fair terms, and this has a positive impact, or this is what we hope to achieve with our measures, on their sales volume, their profits, their employment, etc., etc. Now, for importers and especially for users of the product, this also has an impact. They now source on what we call fair terms, but they're facing price increases, an impact on their costs, and they may even want to change sources of supply and find an alternative source. This is why it's important that companies know about this. Which takes me back to the resources online for small and medium companies. And this is why we have created a specific website and also a help desk. The objective is to facilitate access. And here you have some examples of what is there. I mean, there is general information on trade defense, the rules, the deadlines, the rights of parties. There is a guide for small and medium companies and an online course on trade defense also for small and medium companies in all union languages. As I said before, the process is demand-driven, so we also have a guide on how to draft an anti-dumping complaint. That's also in all union languages. You have a link to our ongoing investigations and past investigations website. This could also be very useful because there we have all documents for all ongoing and completed investigations. We have the regulations imposing duties, the initiation of the investigation, and we also have the questionnaires we use and we request companies to fill. So a company could go there and have an idea of what would be requested from them in an investigation. Finally, a third thing, this is not about the union investigating, but about other countries opening an anti-dumping investigation or a trade defense investigation against the union, which would affect union exporters. For that, we also have a guide to third country investigations in all languages as well, so also in Italian, that would help you understand the process and sail through it and see how you can cooperate. And finally, you have the contact details of the small and medium enterprise help desk that replies to general queries. It's not investigation related. When we open an investigation, you can contact the investigating teams directly. So for two examples, this I explained already. These are the kind of questions that for which you could find information. I mean, a company that feels that they're losing sales to dump foreign imports, they would find the guide for complaints, they would find general information, and they would have the contact of the complaints office, which is the department here that initiates the investigation. The same, if you're an importer and you want to know whether what you're importing might be subject to an investigation, you can go to the website, you can visit the guide to see what you can do, how you can react. You can visit our website for ongoing investigations and subscribe to the RSS feed because there you will see what's going on. And you can also contact the SME help desk. Okay, and that takes me to the end. And this is how trade defense has worked for small and medium enterprises. I mean, the experience of the Commission has shown that the small and medium companies can use trade defense instruments to their benefit. I mean, here I put some pictures of some products where we have trade defense measures in place, the role of Italian interest, and these are three products, or rather five, where Italian companies, and especially small companies, cooperated in the investigation, and their cooperation was crucial. For example, we imposed definitive anti-dumping measures on fasteners from China in February 2022, and on ceramic tiles from China in 2011, and India and Turkey, we have talked about this, in February this year. In both cases, the union industry was fragmented. They were made up of many small and medium enterprises. Many of them were Italian. For example, for ceramic tiles, Italy represents 1/3 of union production. And what success in finally imposing these measures tells us that organization at EU level was critical at initiation stage and during the investigation, that the cooperation of companies was also critical. And it tells you that it's doable, that these sectors, even if made up of SMEs, can benefit from trade defense. Some other products where we have this is bicycles, both electric and conventional, ceramic tableware, or iron or steel fasteners. So to conclude, finally, knowledge of trade defense can help your small and medium enterprises, whether you're producers, importers, or users of the product. Visit the website. You can contact us at any point. And finally, a message from the Commission. I mean, if small and medium enterprises, association of small and medium enterprises in member states want to know more, we are available to organize, in cooperation with member states, some seminars specifically targeted at the small and medium enterprises. And that takes me to the end. And if there is time and appetite, I'm happy to take questions. Thank you.
Grazie ad Enrique. Niente, volevo sapere, siamo rimasti in pochi, però volevo sapere se c'è qualche domanda da fare a Enrique, altrimenti ne pongo io una che ci hanno posto online, anche se credo che non sia molto attinente agli strumenti di difesa commerciale che trattiamo noi, ma piuttosto riguardi la difesa dei brevetti e dei marchi. Enrique, mi senti? Do you hear me, Enrique?
Yeah, yes, I'm still
Okay.
here. I
Yes.
can hear you, but you can ask the question, but I don't think trademarks and patents have anything to do with this. But okay, we can take note.
Yes, I think so, but I prefer to read the question by a firm, an Italian firm. How does trade defense coordinate with the principle of exhaustion of trademark right, Article 15, first paragraph, Directive 2015 number 2433, and Article 13, Regulation 2017 number 110 and 1, which already allowed the trademark owner to stop parallel imports in EU regardless the presence of dumping? Thank you.
Well, as I said in my presentation, trade defense is about putting a remedy, normally a duty at the border, in three concrete instances. This is dumping, this is subsidies, and also in safeguards, where normally instead of a duty, we put a tariff rate quota, because this is a volume issue against a massive surge of imports. Trademarks have nothing to do with trade defense.
Yeah.
And if I understand the question, the problem might be something for customs or customs administration according to a different legal basis, but according to a basic anti-dumping regulation, well, basic regulations, we can only act against 3 things. So I don't think I have an answer to that. Thank you.
Thank you very much, Eric. Just to be sure, we thank you very much. Thank you very much. Bye-bye.
Bye-bye. So there are no more questions, right?
No.
Okay, so thank you to everyone that stayed and to the interpreters and to the Italian colleagues from my side.
Grazie.
Bye-bye.
Allora, grazie, la conferenza si chiude qui. Ringraziamo anche noi tutto lo staff di collaborazione, gli interpreti e tutto lo staff che ci ha aiutato, e grazie e alla prossima. Arrivederci.